Hello and thanks for watching. My name is Tim Cole and I'm an assistant professor at the UNT Dallas College of Law. Today's discussion is on understanding the reality versus the myth of expunctions in the state of Texas. One of the biggest myths about expunction is whether or not a deferred adjudication really ever goes away, and the simple answer to that question is no. In some cases, your criminal record will not and cannot be expunged. The reality is that if you successfully complete any type of deferred adjudication, like community supervision or probation, that disqualifies you from getting an expunction. So you should always double check your records or consult an attorney to evaluate your eligibility for expunction. In Texas, the courts have made it clear that the purpose of expunction is to correct an arrest or conviction that should never have occurred. That means if you were found not guilty of the offense against you, then you may be able to get an expunction if you don't get convicted of another offense from the same incident or have any other offenses pending against you for the same thing. But there is hope. If you were wrongfully arrested and were not prosecuted or charged with a crime, then you can have your record expunged. However, there is a waiting period to have that done. To put it simply, the waiting period generally works like this. For a Class C misdemeanor, such as a speeding ticket, you must wait 180 days. For a Class A or B misdemeanor, the wait is 1 year. For a felony, the wait is 3 years. There are a few exceptions to these rules, but again, you should discuss your situation with your attorney. There are a few other ways you can get an expunction. One way is to have the charges against you dismissed. How do you do that? How do you get charges dismissed? Well, charges you can be dismissed if the arrest was the result of a mistake, false information perhaps given to an officer, or if no probable cause existed for your arrest. You can also complete a pretrial intervention program that is approved in the Texas Code of Criminal Procedure. Another way to get the charge against you dismissed is to get a pardon from the governor. The governor is the only one that can grant a pardon. This rarely happens, and to receive a pardon, it's a very long and involved process that would definitely require the assistance of an attorney. Now that I've told you who and what qualifies for an expunction, you probably want to know the process for requesting an expunction. A lot of people believe that they can get an expunction on their own, but the process is complicated. And if you don't know what you're doing, you could decrease your chances of getting an expunction when you actually qualify for it. And if you believe that you qualify for an expunction, I would recommend that you hire an attorney with experience in the Texas criminal justice system who has experience in filing expunctions. That will ensure that your petition is filed correctly and properly and timely filed with proper court. I know this may sound like an inexpensive process, but the good news is once you're granted an expunction, your record will not continue to follow you. You can move on with your life and apply for jobs and not have to worry about this one thing that has been holding you back for so long. Before we close, I also want to briefly discuss orders of non-disclosure. In 2015, the Texas legislature made some significant changes to the statutes allowing the order of non-disclosure to be available to a much wider group of offenders and offenses. The changes were made because the criminal justice system in Texas realized just how difficult it has been for people to obtain expunctions, and in many cases, even orders of non-disclosure. Non-disclosures are now available to people who have successfully completed deferred adjudication, regular probation, or even a jail sentence. A benefit of the non-disclosure order is that it allows offenders to avoid the adverse impact on one's ability to obtain a job or housing. Orders of non-disclosures, like expunctions, can be difficult to obtain, but may be helpful to you if you do not qualify for an expunction. Again, I recommend that you seek the advice of an attorney of your choice to see if you qualify for an order of non-disclosure. If you'd like more information on expunctions and orders of non-disclosure, please visit Accessible Law at the link below. Thank you.